Okay, guys, we're back again this week. Y'all have any questions about the stuff that we covered last week? Any questions about that? We covered a lot of stuff on transcripts, marking exhibits, stuff like that. So, any questions about that? I think we went over billing, a lot of stuff that we covered. So, anyway, no questions? Okay. I told you guys to read 19 through 23. 19 is terminology of the freelance reporter, okay? And the objectives are define and explain various terms that relate to the freelance reporting industry, discuss what deposition reporting is, what a debene essay deposition is, what a deposition in aid of execution is, what a deposition on written questions is, explain how a deposition is called, what interrogatories are as they relate to the deposition, and discuss what statement reporting is, okay? Deposition reporting. Usually a freelance reporter is called to take the deposition in a litigation. This chapter discusses the initial stages of a deposition. A closer look at the deposition is presented in the subsequent chapters. To begin with, a deposition is usually instigated by attorneys who wish to gather information regarding a civil or criminal litigation. A deposition may be called an examination before trial. And that's exactly what it is. All it is they want to find out information. So what it is, it's discovery. They want to discover what you know about the litigation that's coming up. And that's what it is. They're asking questions to find out exactly what you know. So it is the testimony of parties, witnesses, in the form of questions and answers taken in writing under oath or affirmation before a legally designated judicial officer. Almost all depositions are taken for the purpose of producing a printed transcript. The parties appear for the deposition as a result of a notice, a dedimus, commission, or an order of the court, okay? So you don't just kind of show up. They have to give you notice, so you have to be served. Here, we served you, we're gonna take your deposition. You have to show up on such and such date at the law offices of such and such at whatever time, and bring these documents if you have these documents. Okay? So they have to give you notice that, you know, they're going to be taking this deposition. Depositions make up the majority of the daily activity for most reporting firms. Depositions are essential in the judicial process to bring a trial to a speedy and fair conclusion. Without them, litigation in the United States would be hopelessly deadlocked. And it's true, because they don't want to get a witness on the stand and they have no idea what he's going to say. You know, they've already asked him questions. So whether it be through written form of interrogatories or whether it be through a deposition. Okay, so interrogatories are, they give you this sheet and they ask you all these questions and then they go through them and then see, you know what, I think he may know more than, you know what, we need to take his deposition. End up taking the deposition. Or it's like, you know what, this guy didn't know anything. You know, somebody said that he was a witness to the accident and he didn't know anything. So he's not even going to be worth calling. Why would we call him? So, two types of depositions are used. Those taken on oral examination and those taken on written, and that's just what I explained. So, you know, the bene esse deposition. The bene esse literally means for the good of the record, or for perpetuation of testimony. A de bene esse deposition may be used at the time of trial when the person testifying is not available for trial. Such depositions are used in the case of the impending death of a witness, a maritime or military person who is overseas, an individual who becomes ill to testify, or a person who resides at a great distance from the place of trial. Doctors, important business people, and heads of government may give their depositions the bene esse. Counsel who requests a deposition must be able to prove these facts to the court in satisfaction before they are taken. So what it is they'll use their testimony because it's certified to by a court reporter that this person actually said this. And it can be introduced into evidence that way because a court reporter has certified that it is true. Okay? So the person doesn't have to be there, but they have to have a good reason why that person can't be there. Okay? Maybe the person gave the deposition and 2 weeks before trial gets in a car accident and dies. You know? Or has some illness where, you know, he's not going to live. You know, I mean, usually when they file, you know, some kind of suit or whatever, sometimes it'll take a year or 2 years before it even goes to trial. You know, and then they find out that this person has cancer and is going to die in 6 months or 3 months or whatever. So they can use that deposition of that person and say, hey, look, I mean, this came up, this person died before trial, and we want to use his testimony. Or a lot of times doctors don't want to come in, and doctors are expensive, I mean, for their time, and they want to be paid, you know, so, you know, a lot of times, you know, they want to be on call. It's like, no, we need you down there because that judge says when that witness is done, we need the next witness there. Okay? I charge $1,500 an hour or $1,000 an hour. Okay? Well, we've already taken his deposition. We know what he's going to say. We're going to ask him all the same questions. So we can use it, you know, in trial that way. We'll just use his deposition. Or it's a videotaped deposition, and they'll use the videotaped deposition of the doctor instead of calling the doctor in. Okay? So that's what that is. Discovery deposition. Most oral depositions are taken for the purpose of discovery. That's just what I said. Discovery depositions are reported before a trial begins to elicit evidence that will give information concerning the facts surrounding the litigation. These depositions act as a settlement device wherever possible, thus saving the court time and money. So they don't want to go into trial and, you know what, we're going to call all these witnesses. We have no idea what they're going to say. Oh man, if we would have known that, we could have settled the case. No. So they take depositions to find out discovery, and it's like, you know what? Our client did do it. You know, now we need to talk with the insurance company and say, hey, look, we don't want to go to trial. We need to find some kind of settlement. I mean, he did it. We have witnesses that say he did it. So, you know, we found out through discovery, through a deposition, that it was true. So we need to, you know, and it kind of helps when they go to mediation too. Well, we took the deposition of Dr. So-and-so, and he said, you know, this guy's going to have, you know, disc problems for the rest of his life. You know what? Well, yeah. So then the mediator will come back and say, you know, this is a fair settlement. You need to probably settle. Okay? So that's why, you know, discovery processes are good because, you know, it keeps you from going to trial and wasting judicial time when you could have just settled the case. Okay? They also serve as a preparation aid for counsel in conducting the trial itself. They prevent witnesses and parties from changing their testimony at the time of trial. It can also serve as the basis for the impeachment of a witness at trial. To impeach a witness is to prove that he or she has lied or changed the original facts by that witness. So a lot of times they can use that testimony to come back and say, well, that's not what you said in your deposition. What? Yeah, right here. Page 38, line 18. You said that you had no idea how the accident was caused. Now you're saying you know exactly how the accident was caused. Or vice versa, whatever. So they can use it to impeach a witness. Discovery depositions narrow the issues of a case and allow opposing counsel to determine their adversary's theory of the case. Depositions may be taken for the parties to a case. A deponent is one who gives a deposition. So that's what they're called, the deponent. Deponents include expert witnesses such as doctors, police officers, investigators, or eyewitnesses who saw or heard and can testify to the facts surrounding the case. The plaintiff is the person who brings the action. This is stuff that we've already discussed way in the beginning. Plaintiff, defendant, and the plaintiff is the person who brings the action against somebody else. Most pretrial depositions are taken with counsel for both sides being present. And they're usually always present, regardless of who they're deposing, whether it be the officer, a doctor, both sides have to be there. They have to, okay? So that they can object or whatever. You can't just ask, whatever you want. So both sides are usually there. More and more criminal trials are using discovery depositions to bring out important facts surrounding an investigation. Criminal depositions must adhere to certain restrictions. For example, the work product of law enforcement officers may not be secured through deposition questioning. Also, privileged matters of self-incriminating material cannot be obtained through a deposition. Discovery depositions serve to lessen the possibility of a surprise during the suit in court. So, usually when you go to court, everybody already knows what the facts are, okay? There's usually not very many surprises. Everybody needs to know kind of what's going on. So that's why they ask for discovery. Look, we want everything. We want all the medical, we want everything. So send us everything that you have, okay? And kind of the same in a criminal investigation, it's the same thing. They have to disclose everything that they're gonna present. Now, the other side has to ask for it. Hey, we want everything. So they have to, fill out a form requesting everything that they have. If not, then, they don't get it. But you have to say, well, this is a surprise, Judge. Well, why? Well, they didn't tell us they were going to bring this. Did you ask? Well, no. So you don't just get it. You have to ask. And ask for a discovery. In aid of execution deposition. Depositions in aid of execution may be taken after a case is completed and the court has ordered a money judgment against a party. This type of deposition is used to list the assets of the losing party so that a determination can be made about how and when a judgment should be paid. This type of deposition is called a disclosure deposition, because it is used to reveal financial information. In the 2.5 years that I was doing freelance work, I don't think I ever took one of those. They usually ask everything. So I've never taken one, in a case where they lost the case and we're gonna take the deposition to see what assets he has. I never have. I'm sure they exist, but obviously they do. But I had never taken one. So, depositions on written questions are similar to written interrogatories with one important distinction. The person answering the questions is required to appear by subpoena. The written questions must be served to the answering party along with notification of where and before whom the questions are to be answered. Some states offer the opportunity to cross questions and, if necessary, redirect and recross questions. Depositions on written questions are interrogatories in which the witness is compelled to answer the questions before a designated officer, usually in the presence of the court reporter. A notice of taking deposition on written questions is shown in 19.1. Did y'all see it? Calling the deposition. When statutes do not require written notice of taking depositions, many are set up by friendly telephone calls between counsel who agree on the time, place, and the witness to be deposed. The freelance agency is called and asked to send a reporter to the scheduled deposition. The reporting firm is responsible for making sure that a court reporter is assigned to the particular deposition. All reporting firms maintain an appointment book and computer-generated calendar. The calendar lists the date, time, place, name of the reporter assigned, and other pertinent information that may be necessary. To avoid any deposition appointment not being met, most agencies make provisions to ensure a quick replacement for the original reporter in cases of illness, absence, or lengthy prior assignments. If a written notice of deposition is required, it must state the title and venue of the action, the name and address of the person given the notice, the person before whom the testimony will be taken, the time and place of the deposition, and the name or names of those who will give testimony, and the matters of which the person will testify. And that's on 19.2. Attendance of witnesses for depositions can be ordered by subpoenas. In the case of a subpoena ducis tecum, the required books, records, and other objects demanded must be brought by the witness to the deposition room. And that's all that means. A subpoena ducis tecum is, it's asking you to bring something. Ducis tecum, I guess, means to bring something. So they're either gonna ask for some kind of records, books, logs, whatever. Okay, and that's what a subpoena ducis tecum is. So you'll hear that a lot, because usually, doctors' offices, stuff like that are always asked, we'll serve them with the subpoena ducis tecum on all the records for their client. Okay, so then they have to supply a copy of all of the records and take them to the deposition. And usually that's what the deposition entails, because usually they don't know much other than, they'll ask them, are these the true and correct copies of all of the records? Yes. Are you the custodian of records for this office? Yes. Okay. And that's usually pretty much what it entails.
Is that the same thing that a grand jury would request? I mean, like if they were requesting records, is that the same?
Yeah, probably. Probably. I don't know exactly what they. Yeah, I guess it would. I mean, if they're requesting the records of something, yeah, it would have to be. The reporter may be required to prepare these forms and arrange for proper service. Care must be taken to prepare the forms properly and to follow all required procedures in accordance with each state's requirements to prevent a witness from failing to appear at the proper time and place. Freelance reporters may be called to report pretrial matters, preliminary investigations, and grand jury examinations when the official reporter is on sick leave or vacation. Interrogatories are a type of examination or method of discovery by which questions are already written and sent to the examining party. The written questions are then answered either in writing or orally. In some states, the written interrogatories are served to the defendant along with the complaint and summons. The defendant is then required to answer the interrogatories within a given amount of time. In the case of a deposition type interrogatory, the answering party usually responds to the questions in front of a lawyer who has called a freelance agency to use the services of a court reporter. The lawyer reads questions and the witness responds. The court reporter then produces the transcript that is signed and filed as a deposition. Okay? So that's really all they do. They usually send them the interrogatories. They get to look at them. Hey, you need to be here on that day or whatever and be ready to answer these questions. Okay. So they just read the questions and the witness answers them and the reporter takes them down and then you produce a hard copy of what just happened. interrogatories may be taken for the purpose of securing records. That's a subpoena deuces taken. So when they produce the interrogatories, that's also what they want too. Questions of, you know, hey, these are the medical records. How many medical records are they? What do they consist of? Are you the custodian of records? Blah, blah, blah. So these questions may also be a set of standard questions used over and over again to secure information regarding frequently occurring situations. For example, automobile accidents, pedestrian mishaps, falls, customer restaurant complaints, and passenger claims. Interrogatories may not be answered. There may be a motion to quash or end the questions, or there may be cross-examination to the interrogatories to be answered by the initial party. Costs are usually paid by the attorneys who initiated the direct interrogatories. So they may say, you know what, this has nothing to do with anything. You know, we're not going to answer these questions. So, you know, they set a motion before the court. You know what, we want a motion to quash. And motion to quash means just to do away with them. You know what, he shouldn't have to answer these 2 pages of questions. I mean, it has nothing to do with anything. It's asking about his education. You know, and this is an automobile accident. Don't see how it's pertinent. And then the judge decides, you know, whether they should be answered or not. Sometimes a court reporter is not required to answer interrogatories because they may be answered in writing by the responding party. The secretary for the attorney may receive the responses from the witness, transcribe them, and then mail them back to the lawyer. So a lot of times the court reporting firms are the ones who send out these interrogatories. You know, they send them out, whatever. And then if they want them taken down, then they do a deposition by interrogatory, okay, where they answer these questions. But sometimes they'll just have their secretary generate these questions, send them to the witness or whatever, and then they just answer them and send them back. And that's what they're saying right there. Written interrogatories are often directed to secure records, to assess the value of a case, and to settling without costly litigation. Scheduling interrogatories may be less expensive than setting up depositions. For many cases, they provide a valuable evaluation tool that will show the strengths and weaknesses of the case. And that's just it. I mean, you know, if they send it